Minister, you mentioned tougher bail restrictions in your opening statement, and in the 2024-25 departmental plan, it does mention a key priority being supporting survivors and victims of crime. I'd be curious to know why you think police officers like Sergeant Lisa Harris from Newfoundland and Labrador had to appear before the Status of Women Committee last week asking your government for stricter bail conditions, and why police unions across the country right now are begging you publicly to introduce stricter bail conditions if you believe you've already delivered that.
Minister.
Thank you, Mr. Giovanni, for the question. So what I'd say is that we heard loudly and clearly about the need for bail reform, and we responded to that request that came about 18 months ago. What I'd say about police is that I understand the concerns about police. I feel their concerns. I also know that in my city, close to where you represent, sir, we have 700 less police officers amongst the Toronto Police Service than we did when Bill Blair was the chief of police. I think we need more policing, but we also need more resources dedicated by provinces in things like courtrooms, crowns, JPs, and detention facilities.
There's this sort of condescension in what you're saying, though, when police officers use their voice to express their concerns, and you just sort of dismiss it as, well, we dealt with this 18 months ago. They're tweeting at you now asking for stricter bail conditions. And, you know, I've seen you respond to the Ontario government, for example, and suggest that bail law is very difficult to interpret for those without a background in law. There seems to be a streak of condescension, and I'm asking you quite clearly if you're willing to take any responsibility for the problem that police officers are articulating to you, the problem that survivors and victims are articulating to you now.
I take a lot of responsibility for keeping Canadians safe. That is my job. I respect the job that police officers are doing in terms of putting themselves in the line of fire to keep us safe. What I also take cues from are from police officers, including Deputy Chief Alvaro Amida, who has said in York Region that the problem is resourcing in the system, including the availability of court space and crowns. The National Police Federation, an umbrella organization that represents officers around the country, has pointed out the exact point that I've been making, which is that in some jurisdictions, JPs need to have legal training if they're going to make decisions about charter interests. That is not the case in Ontario, and that's an open question as to why.
So I've heard you make this point before, and ordinarily when you speak, you seem to leave out entirely the principle of restraint, the part of the criminal code which many people point to as a source for a lot of the bail issues in our country right now. I'm wondering if you will admit today that the principle of restraint being introduced by your government was a mistake, and that is actually a big part of the problem, that you have not used your powers through the criminal code to enforce as strict bail conditions as many of these stakeholders, these police officers, these victims, these survivors are asking you to do.
So what I'd say, Mr. Giovanni, this predates your time in the Parliament, but when we passed Bill 75, what we were doing is codifying Supreme Court case law, including decisions like Antic and Zora. Nothing changed in terms of the jurisprudence being transferred into black letter law in the statute. In fact, the only thing that did actively change was imposing a reverse onus on people that commit intimate partner violence, making bail more difficult for those individuals. So I appreciate the concern you're voicing. I appreciate the crisis that is happening on our streets. I appreciate the crisis of confidence that Canadians feel in terms of when they see people being let out on bail who have been subject to repeat offenses. The second ground of bail, it's called there's a primary, tertiary, secondary, tertiary ground, is a serious risk of reoffending. That test needs to be applied adequately by the adjudicators, and that involves also having space to house people.
I understand. The issue, though, and you love to bring up that I'm one of the relatively new MPs, but you've been here for 9 years, and when people hear you speak like someone who takes no responsibility for any of the problems in the system. This is the source of frustration. And when you also fail to acknowledge that the principle of restraint in the criminal code is a problem for people, you might disagree with them, but at least acknowledge that their point of view is legitimate, that when police officers ask you to make change, they're coming from an informed position. When victims and survivors ask you to make change, they're coming from an informed position. When provincial governments ask you to make change, they are coming from an informed position. And you continue to take this posture that you know everything, that everybody's wrong, that I just got here. You've been here for 9 years, but somehow that means that you know what you're talking about and I don't. And yet what I'm relaying to you is not my opinion. What I'm relaying to you is what we are hearing from Canadians and organizations across our country. So are you taking the position that everybody just doesn't know as much as you do, and they just simply need to maybe read more of your tweets or your posts to understand better what's going on in the country?
With all due respect, Mr.
So,
Giovanni,
Minister,
my
you
response
have
to your,
time to respond,
yeah,
and
my
that'll be
response to your
time.
earlier,
No,
pardon?
you've got 50 seconds, and that'll
Thank
be
you.
time.
With all due respect, Mr. Giovanni, when you asked me, do I take responsibility? I said that is my responsibility. So I take responsibility. I've just said it, and I've said it twice, Mr. Giovanni. If I can continue,
do it.
If I can continue, what I would say to you is that I'm also taking cues from all of the stakeholders in the system. And what is fundamental for Canadians to understand is that you can amend the criminal code, but the implementation of law enforcement is something that resides at the municipal level and at the provincial level. And when I hear Donna Kelway of the Ontario Crown Attorneys Association lamenting the lack of resources so that there are enough crowns to argue about bail, yes, I think that's something that needs to be remedied at the provincial level. When I hear justices of the peace lamenting the fact that the Toronto South Detention Centre is so overcrowded that it resembles third world conditions, there's yet another article in today's news about that very issue. We're jeopardizing the entire criminal justice system. So we need amendments at the criminal code, some of which I've delivered, and I'm willing to entertain more suggestions for further. But what I would say secondly is that if I could finish, Mr. Giovanni, what I would say secondarily is that we need more cops, more crowns, JPs with legal training, detention centres, and we need data. The fact that we don't have the data, and yet Mr. Ford's governance of the criminal justice system is resulting in more than 50% of sexual assault charges being stayed or withdrawn is a problem for everyone in Ontario, including the victims that want to have their day in court. And they're not getting that because there's not enough resources being dedicated to the system.
So thank you. Mr. Van Popta, please.
Good. Thank you, Mr. Minister, for being here with us today. According to the departmental plan, the percentage of Canadians who have confidence that Canadian criminal justice system is fair to all people stands at 50%, only at 50%. I find this shocking. So my question is, how is that conducive to a strong, free, and democratic society that half of us don't have confidence in our criminal justice system?
Well, to be frank, Mr. Van Popta, what I'd say is that confidence in the criminal justice system gets undermined by two things. One is underinvestment in the system, particularly in terms of building the infrastructure, having the personnel to staff the system. But secondly, it's about people taking shots at and encouraging disrespect for our judiciary, including members of the Supreme Court of Canada. And I've unfortunately seen that on repeated occasions from none other than the leader of the Conservative Party, and I don't think that helps with the narrative about building up confidence in our institutions.
People express concerns. We hear it all the time. Are you suggesting that those concerns aren't real? And I'm thinking that maybe you don't, that you don't believe them. You had said shortly after you were appointed to your current position, I think that empirically it's unlikely Canada is becoming less safe, but I think there's a sense coming out of the pandemic that people's safety is more in jeopardy. So, you know, it's in their heads, right? Empirical evidence suggests otherwise, but I'm looking at a recent study from the Fraser Institute about our worsening public safety record compared to the United States. And since 2014, violent crime is up in Canada and has now surpassed that of the United States by 14%. And property crime also exceeding the USA by 27%. So can you acknowledge that the subjective feelings that Canadians have about a worsening public safety situation is not just in their heads, but is backed up by empirical evidence?
There is absolutely empirical evidence of worsening crime statistics. I acknowledge that full frontal. And what I would say to you is that when we're concerned about people's perceptions of crime, it's about their confidence in our institutions. And I think when we have decisions that are being rendered and we're having underinvestment, it erodes that confidence. So what I would point to is some of the interventions I made earlier about the need to ensure we have enough police officers, enough Crown attorneys, enough courtrooms, enough court space, and enough detention facilities to house individuals. It's not lost upon me that actually 81% of the people in Ontario are actually on remand right now, so they're awaiting trial. That's a pretty startling statistic for most people to digest, but it's also not lost upon me that JPs and judges are commenting on the deplorable conditions of said detention facilities as a disincentive for them to deny bail and keep people housed. That's really, really important to underscore.
Yes, we've heard that from you recently, that trying to shift the focus to provinces, and they should be doing their part of under shared jurisdiction under criminal law. but yet Bill C-75 is a federal law which focuses on the principle of the least restraint possible. So that's your law. So is there, and we hear so many people expressing concern, police authorities and premiers saying more needs to be done when it comes to bail reform. Now, is the concern with stricter bail conditions one of perhaps it being challenged as being unconstitutional? And in this environment today where repeat violent crime is really becoming a scourge on our society, like, doesn't that pass the Oakes test under Section 1 as being an immediate problem that needs to be addressed, and that stricter bail conditions could pass a constitutional test such as that?
Well, we imposed stricter bail conditions through Bill C-48, which is important, and that dealt with serious violent repeat offenders. Whether that's being applied and implemented in an appropriate manner by justices of the peace who do not require any legal training in the province of Ontario is a question that I think every Canadian should be asking, particularly every Ontarian. What I would say to you, I'm glad you bring up the Constitution, Mr. Van Popta. I don't think it helps to support Canadians' confidence in our institutions or in the judiciary or in our legal system when the response to what needs to be investments is simply to say we should contemplate invoking the notwithstanding clause to override charter rights. Because that's exactly what's come out of the mouth of your leader, unfortunately.
I just want
and that to me is
that.
Problematic for somebody who professes
I'm talking about
to be
the
established
Section 1
freedoms
test.
as opposed to overriding freedoms.
I'm sorry, sir, you're trying to put words in my mouth. I'm not talking about a notwithstanding clause. I'm talking about laws passing through the Section 1, the Oakes test, as
Time's
being
up.
constitutional.
Thank you. But now, Mr. Brock, you have 5 minutes.
Thank you, Chair. And all my questions can be answered by any official, no one in particular. I want to push back a little bit and correct an error that I believe the government is pushing through the House and delivering to the public. I know the minister spoke about Antic and Zora in response to a question regarding the failings of Bill 75, but I want to have everyone reflect on what those two key seminal decisions pronounced. It indicated as follows, that for most alleged crimes, release on bail at the earliest reasonable opportunity with minimal conditions is the default position. These decisions make clear that the principles operate alongside the grounds for detention and do not replace them. That is very specific language. Do the officials agree with the ratio of those two key leading decisions, yes or no?
Yeah, thank you for the question. I agree with everything you've just articulated, Mr. Brock.
So then why is there an imbalance, a specific wording imbalance that has created the crisis that this country has seen with respect to bail decisions? 493.1 was amended by the Trudeau government in 2019, and it reads, in making a decision under this part, a peace officer, justice, or judge shall, mandatory language, shall give primary consideration to the release of the accused at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances. Language right out of the Supreme Court, including conditions that are reasonably practical for the accused to comply with. And then at the very end, a tagline, while taking into account the grounds referred to in Section 515, sub 10, the primary, the secondary, and the tertiary. That is not a balance. That is telegraphing to justices of the peace and judges that default is the primary consideration, regardless of the predicate offense, regardless of the offender's criminal record, regardless of a track record of breaches of the administration of justice, and regardless of overall his background. Is the current government open to strengthening the language under 493.1, where we're dealing with individuals who are creating the majority of menace on our streets, continually violating bail conditions, Is the government open to the possibility of amending that language in 493 to ensure that judges are placing equal emphasis on all three grounds enumerated under 515 sub 10?
Thank you for the question. I think you emphasized a couple really important points that bear repeating. That 493.1 operates alongside the primary, secondary, and tertiary grounds of bail, Mr. Brock, such that where detention is warranted, detention should be imposed. Minister Virani did allude to his openness to looking at ways to further strengthen the bail system, and just to
Mr. Taylor, how long do victims, how long do premiers, how long do police chiefs, how long do presidents of unions have to wait while this government sits and considers? We are in a crisis. Victims are so disappointed in this criminal justice system. I hear from them daily. My colleague Michelle Ferreri hears from them daily. Mr. Van Popta, Mr. Jamil Javani, we are hearing from victims. We are hearing from stakeholders. This government is not ensuring a balance. How long will it take for this government to provide the necessary tools to judges and justices of the peace so that they can hold those repeat violent offenders accountable?
It's a good question, and unfortunately it's one that's best addressed to the minister. I can say that we are working very actively with our provincial partners. We hear those concerns as well as public servants responsible for advising the government on the criminal justice system. We work with our provincial partners. We work with policing partners. We're alive to those concerns, but as to whether law reform would be advanced either by the government or Parliament, that's not for me to comment. Thank you.
Thank you very much.
Ms. Ferrari, you have 5 minutes. Thank you very much.
Thank you so much to the officials here. So what we have here is we have officials from the Minister of Justice's office. These are the folks that are working alongside this office. And, we just heard testimony from the minister, and to call it appalling would be kind, to be honest with you. As somebody who sat in the status of women for the last 3 years, who has, listened to the stats on women being murdered in broad daylight, including here in Ottawa, just down the road in a park in front of her 2 children, where her throat was slit and innocent people had to hold her while she died in their arms in front of her children. And the minister said, we've reformed bail, and these people that are committing these crimes are out on bail. It was a very insulting testimony to victims of violence. And so I think it's very pertinent that I move the following motion. It was put on notice on November 26th, and the following motion reads that given the members of Parliament committed to 16 days of action to combat gender-based violence, and that 1 woman or girl is killed every single day in Canada, and that since 2015 sexual assaults have increased 74%, sexual violations against children have increased 118%, kidnapping has increased 10%, harassing communications have increased 86%, and human trafficking has increased 83%. The committee report to the House that Liberal criminal justice policies have failed to protect women, and that the committee undertake a study of no less than 2 meetings during the 16 days of action to combat gender-based violence to hear from survivors of domestic violence, experts, and advocates. And so I'm asking for some retribution, because what the minister said here today in committee was that they've done a tremendous job. He himself has done a tremendous job in combating gender-based violence. And so I'm moving this motion to hopefully get the support of every member in this committee to say, okay, let's study this. Let's actually let victims have their voices heard. We had Sergeant Lisa Harris from Newfoundland Constabulary. She testified in Status of Women last week, and she said, the death of Courtney Lake, and it's really important we say victims' names, highlights the tragic consequences that can happen when those accused of intimate partner violence are allowed to remain free on bail with little repercussions for breaching court orders. Her story is one of many that demonstrates the urgent need for stricter bail conditions for those accused of intimate partner violence. Madam Speaker, if we are serious in this Justice Committee, I would urge every member to vote in favour of this study to bring forward the victims who definitely need to have their voices heard, but also to implement the policies that can be made today to stop this insane attack on women and gender-based violence. And especially in our northern regions where we also have an epidemic. Just a couple weeks ago, we had a young woman who was 16 years old who was brutally attacked in broad daylight. And again, her attacker was out on bail. Police in northeastern Ontario respond to over 100 intimate partner violence calls every single week. We have to agree this is the Justice Committee. If people are serious here, we have to do something. And so I will leave it at that, to this motion that I plead with the members of this committee to take this very seriously, because 187 women were killed violently in Canada. That is one woman every 2 days. And according to Peel Regional Police, a woman is strangled every single day in this country, and we can do better.
Mr. Maloney?
Thank you, Madam Chair, and I want to thank Ms. Ferrari for bringing forward this motion. Look, gender-based violence, well, actually, the minister's on record time and time again describing it as an epidemic. So to suggest that anybody doesn't take it seriously would be a mischaracterization in the extreme. And it is a topic that merits discussion at this committee, other committees, and Parliament as a whole. But I think, given the, I would like to see this motion reviewed very carefully, perhaps expanded. I know that we do have witnesses here today, and we do have our schedule and our timetable full until the end of this session, till Christmas. So I would suggest that I move to adjourn debate to allow us the opportunity to consider this further down the road.
Really putting your money where your mouth is, eh, James? Kate will love that answer.
Yeah, well,
She's watching you right now, just so you know.
and she knows how seriously we take this.
Yeah, real
So
serious.
we have a motion, and I need to call a vote on it.
Mr. Maloney?
On the motion to adjourn.
Okay, gotcha.
We have a motion to adjourn debate.
I just wanted to clarify
Yes.
what we're voting on. That's all.
Yes. And so I need to have the clerk deal with that before proceeding any further.
Mr. Maloney?
Yes.
Madame Brière? Mr. Mancino?
Yes.
Mr. Biddle?
Yes.
Miss Dillon? Mr. Brock?
Conservatives will always stand on the side of victims, so I am voting no.
Miss Ferrari?
Absolutely not.
Mr. Van Popta?
No.
Mr. Giovanni?
No.
Monsieur Fortin?
No.
Mr. McGregor?
Yes.
Yes pour 6, nays contre 5, 5.
So, Madame Ferrari, I'm gonna, you've got, I'm gonna give you 2 more minutes if you like for the witnesses.
I'll take it for sure. Okay, thank you to the chair here. So one of the things that has come up repeatedly in terms of what is not protecting victims on the street who are being hurt and murdered by repeat violent offenders who are out on bail is Bill C-75. Police Chief Stuart Betts testified in Status of Women that said, "We know that the release from custody is a ladder principle and that the least onerous form of custody is to hold that person accountable for their behavior while they're awaiting a trial, and that is what we are letting people out on. Often, that is perhaps underserving victims in our community because the least onerous, depending on the nature of that offence, is insufficient to protect our community once they've been released." A Liberal member then tried to question him and saying, "It's the application of the law, not the law itself, correct?" And Chief Stuart Betts said, "I'm sorry, it is the law itself as well as how it's currently being applied, but it is also the law." So my question to the officials is, what are you doing to change and implement Bill C-75 so that violent repeat offenders are not getting out on bail?
Thank you for the question. Maybe I can say a couple of things. The first I'd point you to is the recent meeting of FPT ministers responsible for justice and public safety. So this is all ministers. provincial and federal, met in October and agreed that there continue to be challenges in the bail system, and agreed that through them, their officials at all levels of government should continue
Sorry,
to
Madam
collaborate.
Chair, and my frustration and anger is certainly not directed at you. I know your officials. But the Minister of Justice is the minister responsible for justice in the country, correct?
The Federal Minister of Justice is responsible for.
10 seconds for Mr. Taylor
So
to
we don't
respond.
need a
No, Ms.
meeting.
Ferrari, he's allowed to respond.
He did. We
No,
don't need a
he d-
meeting. Yes, he did. He
Well-
just responded. We don't need a meeting about what's not
time's up.
working.
I'm
We need
sorry,
we need
time's up.
action from the Justice Minister. Thank you.
Time's up. Thank you.